Greetings. This is the John Savers Variety Spotlight Show. My name is John Savers. I'm your host. Today we'll take a look at a show I hope you find interesting. We try to feature people, ideas, actions that are calculated to interest, amuse, edify. Myself, I have no role other than that of introducing the program. Today we're going to introduce you to...
Hello. This subject is the most important subject that I've addressed so far in this series. There was just recently a young lady. I have not mentioned this person before. This young lady was ostensibly and falsely convicted, supposedly, of a second-degree murder. But it was pure self-defense. Now, the outright lies that were told to the jury about what constitutes murder and what constitutes self-defense and how the two can be distinguished, those lies have got to be brought forward, and I intend to bring them forward into the public view, because the young lady who had a perfect right to defend herself in this case is facing now a very long sentence, which would ruin her life if she's not cleared. The prosecutors agree with the defendants on most of the facts. On most of the facts per se. In other words, who did what and when it was done, the outward facts. They pretend to disagree on the motivation, but they all agree, both the prosecutor and the defense, on the outward facts. Who took what action visibly? Now, there are some slight discrepancies between the defense's version and the prosecutor's version. But even if you take the prosecutor's version, which would be supposedly the most detrimental to the defense case, even if you take the prosecution's version of the facts, you still don't come out with a murder conviction or even a manslaughter conviction. But you come out with pure self-defense. This is what happened. Starting in, July or August of 2008, the girl, the young woman who ended up being killed by the other young woman, that first young woman was taunting and harassing and baiting the young woman who was later made a defendant. Does this sound familiar? Our society, it seems, is good for not much else than taunting and baiting someone. It's done constantly everywhere in real life, and it's done constantly in the world of television and movies, which reflect real life. Everywhere you look, 5 times a day, 10 times a day, someone is taunting or baiting someone else maliciously, taunting someone or baiting someone or harassing someone. And our feeble-minded legislators and congressmen and judges have not had the sense to declare such actions felonies and to prosecute those actions of themselves before there's an escalation to a physical confrontation that results in somebody dying. But what they do instead is even worse than that. Not only do they not prosecute those who maliciously taunt and bait, but they brush it off. And that's why we have an epidemic, for example, of school bullying. And there are children, both here and in England and elsewhere in the world, here in America and in England, where I've seen documentation, and elsewhere in the world too. There are many, many cases of school children actually taking their lives or trying to take their own lives because of school bullying. There was a recent case, a girl by the name of Phoebe, up in Massachusetts, I think it was. Now, the case I'm talking about did not involve school. These young ladies were not in school. They were out of school. They had just, they were in their latter teen years. But one of them was baiting the other one, taunting the other one, harassing the other one. The other one responded or reacted by using rough language to the first one, the one who was taunting her or baiting her. But you see, it requires a wise person, a wise judge, and a wise juror, and also an honest judge and an honest juror, to distinguish between rough language that's a defensive reaction and rough language that is malicious and that is the result of a malicious person who's trying to pick a fight. So all they did in the court case was quote the harsh reaction by the innocent party, the one whom they pretended to convict of murder. They quoted her reactions. But the similar taunting and baiting, not similar, but the real malicious taunting and baiting, I mean the similarly rough sounding, similar in their rough sound, but not similar in their essential nature, because the one set of taunting and baiting that was not shown in court, because there were no recordings of it, was the set of taunting and baiting episodes perpetrated by the one who ultimately was killed. But the only ones that were shown in court were the recordings of the voicemails left by the innocent girl who was only reacting to the taunting and the baiting. Now, I'm going to read one of those voicemails. I'll read it, and then I'll explain why not only does it not show her to be guilty, as they were claiming it does, but it actually shows her to be innocent. She says, "You're talking fighting words to me." Actually, she used a vulgar street expression, which I won't repeat here. But essentially what she said was, this is the defendant talking, the one who was ultimately convicted, ostensibly, of murder. She says, you're using fighting words to me. Quit messing with me. You're a dumb, psychotic bitch. Quit messing with me. You're messing with the wrong person. Now, you say, that sounds like awful rough language, but look at what really counts. What does it tell you? The fact that it's rough language is beside the point. Rough language might be used by a malicious person, but at the same time it might also be used by a non-malicious person who's only reacting to a malicious person. So the rough language doesn't tell you anything by itself. But what does this language tell you, which the court completely overlooked? All the lawyers, the prosecutors overlooked it, the defense attorney didn't make a point of it, and the judge didn't make a point of it. He should have thrown out the verdict, but he didn't. What does this tell you? It tells you that she was being picked on before she ever spoke these words. It tells you that she was reacting to having been maliciously taunted and baited by the other party. And even though she uses rough language and street words and vulgar epithets, that's completely beside the point. The point is she was reacting to a malicious series of harassment incidents or episodes. She was reacting. She was on the defensive. Even if her voice sounded very tough and mean, that doesn't mean anything. A policeman can act very tough and mean when he's on the defensive. And we don't convict him of murder. We understand that even though the policeman is talking rough and mean, he's on the defensive and he's in the right. The one to whom he's talking rough and mean is the one who initially did something wrong. And the policeman is only reacting. Well, it's the same for a person who's not a policeman as it is for a policeman, and in fact it's doubly so. People think, common ordinary people think, that a policeman can do some things by right that an ordinary citizen cannot do. Well, that's incorrect. Stop and think. The policeman is a public servant. All of his rights are vested rights. The citizen is not a servant, but is the sovereign. And the citizen's rights are inherent rights. In genuine law, whatever a policeman can do, a citizen can do better. Not only can do the same, but can do better. In other words, has a better right, a clearer right. The policeman's right is only by license. The citizen's right is not by license. It's by inherent right. If a policeman can defend himself and display some roughness in doing so, 10 times more can a citizen defend himself or herself, even if it involves displaying some roughness. Now, I need to go, it's necessary because I'm going to try to get this girl out. She's facing the complete ruin of her life if she's not cleared quickly. I want to go over what the two prosecutors said to the jury and what the judge said to the jury and show point by point that they were either grossly ignorant of the law or deliberately lying. The first there was one prosecutor who spoke to the jury, then the defense attorney spoke, then there was a second prosecutor. That's the way they do it in some jurisdictions. The prosecutor gets to talk twice to the jury, and the defense attorney talks in between the first prosecutor and the second prosecutor. So the prosecutor gets the first word and the last word. I don't know that that's fair. In fact, I don't think it's fair. But leaving that aside for the moment, the important thing is what they actually said and how they deliberately misled the jury. And I say deliberately because they can't be so ignorant of the law as they seem to be. And therefore it can be deduced that they're deliberately trying to mislead the jury about what constitutes murder and what does not constitute murder, and what constitutes self-defense and what does not constitute self-defense. And by the way, this verdict, this ostensible verdict, came out only a few days ago, and the sentence has not come down yet. It's supposed to come down in a few weeks. Now, the first prosecutor, almost the first thing he said when he got up was false, was a false representation of the law. He said, malice or hatred or spite or ill will. He said, that's what the jury instructions claim the jury must find in order to find a conviction, a guilty verdict for murder, second-degree murder. And he said it has to be only one of the four, either malice or hatred or spite or ill will. Well, three of those four words mean the same thing, but the fourth one means something entirely different. Malice and spite and ill will, those three terms mean exactly the same thing in law. Exactly, precisely the same thing. But the fourth term, hatred, is not the same thing. It is entirely possible to bear hatred to another person without bearing malice to that person, because the word hatred, by definition, includes either rightful hatred or wrongful hatred. When you just say hatred by itself, that does not give you a clue whether it's wrongful hatred or rightful hatred. It could very well be rightful hatred. If someone has been harassing someone else, if Party A has been harassing Party B, Party B might very well develop a hatred for Party A. That is not the same thing as malice. The definition of malice is wrongful hatred or the wrongful desire to see another person harmed or distressed. The key word, the essential operative word, is the adjective wrongful. Where there's no wrongful sentiment, there's no malice, even if that sentiment is hatred. If you have hatred that is not wrongful hatred, but rightful hatred, or defensible or excusable hatred, and not wrongful hatred, then you do not have malice. And if you do not have malice, you don't have murder. It doesn't matter what any statute says. Even if the statute upon which these, or to which these jury instructions refer, even if the statute pretends or purports that only hatred need be shown in order to have a conviction of second-degree murder, then that statute is void, because it's a fundamental principle of law. It is a fundamental, unalterable principle of law that the definition of murder includes malice. If it does not, if the action did not involve malice, then you do not have a murder. You might possibly, hypothetically, in some cases, have a manslaughter, but you do not have a murder if there is no malice present. These prosecutors and the defense attorney and the judge completely and totally overlooked that, pretended to be ignorant of it, but they couldn't possibly be ignorant of it. They went through law school. They've studied the law all their lives. There's no murder without malice. But they were claiming to the jury that if they could show hatred, just hatred, that was sufficient to prove murder. That's false law. That is not the law. That verdict the judge should have thrown out. In fact, he should have stopped them right there, the prosecutor right there, and corrected the jury. Or, failing that, he should have thrown out the verdict once it was rendered. Now, again, the first prosecutor says, you don't have to look any further. He's talking to the jury. You don't have to look any further than the voicemails that the defendant left for the decedent. The voicemails in which the defendant spouted forth angry words. And by the way, with anger, it's the same as with hatred. Anger, like hatred, does not show malice by itself. It would have to be wrongful anger or wrongful hatred in order to show the existence of malice. But simply anger or simply hatred is not the equivalent of malice. Again, a policeman might become very, very angry, and a policeman might harbor hatred against somebody else. But it's not malice unless he acts wrongfully, and unless the hatred itself is wrongful, and the anger itself is groundless. Anger and hatred in and of themselves are neutral terms. They do not equate to malice by themselves. Now, he says you don't have to look any further than the voicemails. The voicemails in which she used that rough language, the defendant. That's false. First of all, those voicemails were recorded 8 months before the decedent was actually killed. 8 months. In the intervening 8 months, that decedent had constantly continued to harass the defendant and actually was chasing her all over town. She went to her place of work and harassed her. And on the night of the event in question, the decedent, the one who ended up being killed, had chased the defendant all over town and had finally found her at that place at which the defendant finally defended herself using force, as she was entitled to do. First, the decedent, the one who ended up deceased, came with several of her friends to the defendant's house, and she called her on her cell phone and said, "I'm coming for you." And after she called her, a minute later or a few seconds later, the defendant heard the decedent outside her own house, the defendant's own house. What did the defendant do? She tried to get away. She didn't want to fight. So the defendant took refuge with one of her friends. She called one of her old friends that she hadn't seen in a few months. She said, "Let me come over to where you are. I'm afraid these people have come to my house to try to pick a fight." The same other young woman that the defendant had left these voicemails for 8 months before, using rough language. Now, she went to her friend's house. She slipped out the back way. I believe that's what she did. She somehow got from her house to the friend's house. She did not tell anybody where she was going. She did not notify the people who were chasing her that she was going to another location. She tried to get away from them, so she did not tell them. But they found her. They guessed, or they somehow found out where she went, and they tracked her down there. So they chased her 2 different places at least that night. First they chased her to her house, or they tracked her down at her house. They came looking for a fight. Then they tracked her down at her friend's house. And the defendant had taken a knife from her kitchen with her when she left her house and went to her friend's house. But the important point is the decedent and her buddies, her gang of buddies, she had 2 or 3 other people with her who were sympathetic to her. They chased down the defendant. They chased down the defendant all over town. Now, the defendant took a knife with her to try to protect herself. She had a perfect right to do that. Perfect right. And when she got to a friend's house, when she first got there, she was sitting on the hood of her car, or somebody's car. I think it was her car or her friend's car. And the knife was next to her. Just then, the decedent, the one who was trying to pick a fight, raced around the corner very, very fast. All the witnesses confirmed this. And they started piling out of that van. They raced around the corner in a van. They started piling out. And the defendant saw that they wanted to fight her, and she used that knife to defend herself. The defendant's own version, she took the stand. She insisted on taking the stand, and she insisted on going to trial. Just a little word of wisdom here. That alone is worth 100 credit points on the defendant's behalf. A guilty defendant very seldom wants to take the stand, and very seldom even wants a trial. The fact that she insisted on a trial and insisted on taking the stand gives added credit to her, although she's already got plenty good credit. There's no reason to disbelieve her. But she said on the witness stand that the girl who ended up deceased came towards her and started striking her and pulling her hair. Even though she displayed the knife, and she said her purpose for displaying it was to try to keep the other one back, to try to frighten her so that she would not attack her with fists or with anything else. She didn't know what she might have had. The other side, the prosecution, claims that most of the forward motion on that night was by the defendant, that the defendant moved towards the car as the decedent was getting out of the car. And the prosecutor even tries to hint, he doesn't say it outright, but he tries to hint when he talks to the jury. He admits that the decedent struck the defendant several times and pulled her hair, but he tries to make it look like she did that in order to defend herself against the defendant who had the knife. But stop and think. This is important. Even if that's true, even taking the so-called worst-case scenario under which the prosecution's version of the facts is the correct version, even if that's the case, the defendant is still innocent because they came chasing her from some other part of town. They came looking for a fight. She wasn't looking for a fight. The fact that she had a knife doesn't mean she was looking for a fight. It only means she was prepared for a fight if need be. If the fight was brought to her, she was prepared for it. That doesn't mean that she was looking for a fight. But when they came to her, screeching around the corner, and every witness agrees that they came very fast and stopped right in front of her, almost like they were going to try to strike her. They stopped their truck a couple of feet in front of her. She said it looked like they were going to strike her with the truck, the van. And then they piled out of that van, or started to pile out, and they had come to her, and they had called her on the phone to say, we're coming to get you. In other words, to beat you up. They had called her on the phone that night. Nobody disputes that. And they had gone to her house first, and then they tracked her down at her friend's house because she escaped her house. She wanted to avoid the fight, but she took a knife along just in case. Even if at that scene where the actual confrontation took place, even if the defendant was moving forward more than the decedent was moving forward, that does not vitiate her claim of self-defense because they had chased her from another part of town to that location. Let me tell you something. Now listen, if that defendant, instead of just a knife, had had a bazooka, listen to me, if she had had a bazooka and used it on that van when they came around the corner, before they got out, she would have still been justified. No, I'm telling you right. You see, most judges and lawyers don't understand the law, or they pretend not to understand it. The law allows self-defense before anything else. And there are no Candyland rules in self-defense like these prosecutors were pretending. For example, in one place, not the first one, but the second prosecutor, the one who spoke to the jury after the defense attorney, she says, you can't bring a knife to a fist fight. That's some stupid old slogan, and it's a false slogan. Let me tell you why it's false. It's true only if and when both parties are going to the fist fight willfully, deliberately, and they both want a fist fight. In that case, you might be able to say with some merit that you can't bring a knife to that fist fight. If they both agreed on a fist fight, but that wasn't the case here. They didn't both agree on a fist fight. The defendant didn't want any fight. The defendant didn't want any fight. That being the case, it doesn't matter if the decedent was only going to produce a fist fight. That doesn't matter. Now, let me interject here that for all the defendant knew, it might have been more than a fist fight. The decedent might have had some weapon. How could the defendant know ahead of time? And she's not required to know, and she's not required to gamble. But let us assume that even if she knew it were going to be only a fist fight, but she didn't want any fight at all. She was trying to escape any fight. She had a right under those circumstances to bring not only a knife, but a bazooka. She could have brought a bazooka and used it. She still would have been innocent. Anyone has the right to prevent another person from committing or perpetrating any outrage upon himself. It doesn't have to be a fatal outrage. Any assault, any robbery. If the other one was trying to steal $5 from her, she could have used deadly force. Yes. And in fact, it's done all the time. On America's Most Wanted recently, not recently, but a couple of years ago, an old woman in a store, a jewelry store, an old woman who owned or was the manager at a jewelry store, was in her jewelry store, and a man came in and tried to steal some jewels. He didn't even use any weapon. It wasn't a robbery. It was only a burglary. He tried to sneak them out while she wasn't looking. He didn't even menace her with a weapon. He merely tried to steal some jewelry. She struck him as hard as she could. She saw what he was doing. She turned around and saw what he was doing. She struck him as hard as she could with a stick or something and almost killed him. Put him in the hospital with a serious injury. Nobody prosecuted her, and she was a hero on America's Most Wanted, that weekly program that so many people watch. She was hailed as a hero. This was actually 3 or 4 or 5 years ago. And there are cases all the time in the news in which would-be robbers are killed by the store owner. Now, if mere burglary, which would have only involved a monetary loss, can be defended against by using deadly force to prevent it from occurring, and that is the case, much, much more so can lethal force be used when it's not a robbery or a burglary, which is usually perpetrated out of greed, not out of malice. A robber or a burglar usually is not actuated by malice. He only wants the goods for the monetary gain. Now, that's classified as malice to the extent that it's wrongful, but it's not the same degree, the heinous degree of malice that consists of desiring to harass or hurt someone for the sake of taking pleasure in the other person's pain or distress. That's not the actuating factor in the case of a robber or a burglar. But in this case, it was. In the case of a bully or one who's harassing another, you have pure, unadulterated malice. Pure, unadulterated malice. And if mere robbery can be defended against with lethal force, and it can be, and nobody disputes that, nobody takes issue with that, then a fortiori, as the lawyers say, which means much more so, is it the case that a malicious assault or any malicious harassment, especially when it would involve actual bodily contact, even if it's with the fist alone, even if that other party, the one who ended up being killed, was only going to use her fists or her hands to assault the defendant, that defendant had a right to use lethal force. The decedent was much bigger, taller, and heavier than the defendant. There were 3 or 4 others with her, including several that the defendant was already apprehensive of, because they had also menaced her and and threatened her and harassed her in the past. She had a right to do what she did, and in fact, she had a right to do much more than what she did. She didn't even have to wait for them to come out of the car. If she had had some means of stopping them, even by destroying them, even by taking their lives, while they were still in that car, she could have done it and still been innocent under those circumstances. They say in another place, these prosecutors, that the fact that she seemed calm and contented afterwards indicates that she had malice. That's a lie. It indicates no such thing. No such thing. She was under no obligation to start blubbering just because she had successfully defended herself. She was under no obligation to start crying. She was entitled to remain calm, and she was entitled to be content. That does not indicate malice on her part. Now, listen to me. This fellow, this first prosecutor, he uses the word impart, I-M-P-A-R-T, the verb impart, instead of the word impress, where the word impress was the correct word. He says, so-and-so has tried to impart upon all of us. What he was trying to say, or what he should have said, was so-and-so has tried to impress upon all of us. Now, why do I make note of that? Because it shows that he's got a slipshod brain. He uses one word when the other word is the correct word. And he did the same thing when he says that hatred is just as good as malice for proving murder. Not so. Not so. Now, he says here, these are his exact words. She, the defendant, armed herself for what was going to be at best a confrontation, meaning a verbal confrontation, and at most, or at worst, a fist fight. How does he know that? First of all, how does he know it was going to be at worst a fist fight? It might have been something much worse. It might have involved weapons on the part of the decedent, the one who ended up being killed. She might have had weapons. The defendant wasn't obligated to gamble. Second point, even if it were only going to be a fist fight, the defendant didn't want a fist fight. The defendant didn't want any fight. And so even if the others came to her with their fists alone, the defendant had a right to use a knife. Yes, she did. Now, he says, she did not merely stand her ground, as the defense attorney had argued, but she took ground. In other words, she stepped forward. That doesn't mean anything. At that point in time, she was entitled to step forward and take the active part, and that does not vitiate her claim of self-defense, because the others had come to her from another part of town. The others were looking for her. It was the others that wanted to fight. She didn't want to fight. She was only prepared to defend herself in case the fight came to her. At that point, when it did come to her, she was entitled to move forward, if that was the tactical thing to do. She was entitled to step forward, even if it involves taking several steps forward. In fact, even if, as I said, when the truck was, or the van was still coming, if she had raised a bazooka or a rocket launcher to her shoulder and stopped that truck even before they got out of the truck and ended up killing several of them, she still would have been innocent. She still would have been innocent. That would not even have been manslaughter. That would have been perfect self-defense. No one is obligated by the law to take a scratch or a busted lip. This is another argument that the second attorney tried to make. She said, at most it would have resulted in some scratching or a busted lip. Do you think for 1 minute that the law requires anybody to suffer a scratch or a busted lip when they could prevent it? No. The law entitles you to prevent any such thing. It doesn't have to be the worst, most mortal kind of injury. Any wrongful injury you can prevent, even if you have to use superior force to prevent it, even if you have to use lethal force to prevent it. No one is ever obligated to suffer a busted lip or a scratch. And if the only way you can effectively and safely prevent that is by using lethal force, you do that. You use the lethal force. Why do you think the FBI has as its own rule that you always shoot to kill when you shoot somebody? You never shoot somebody to wound them. Why? The FBI has explained this before in public. They said because that's the only safe way. That's the only safe way. If you're going to shoot somebody and you have the right, you better shoot to kill, not to wound them. If you wound them, they'll be more dangerous. It was the same thing here. Suppose she had tried to use only her fists. That would have only made the others more dangerous. That could have gotten her seriously injured or killed herself. And that's all she had an obligation to worry about. Since they were picking the fight, since they had come from another part of town looking for her, she didn't have to worry about them. She only had to worry about herself. Now this second prosecutor says, one thing is sure, if she had not brought a knife if she had not brought a knife with her when she was trying to escape from any fight. Remember, she didn't bring it to a fight. She brought it with her when she was in the act of trying to escape from any fight. She went to a second location to avoid the fight, but the others came around the corner and they found her. She said if the defendant had not brought a knife with her, one thing is sure, the decedent would still be alive. That's irrelevant. And this prosecutor knows it. The defendant was not obligated to worry for 1 second about whether the defendant would still be alive or not. That wasn't the defendant's problem. That was the decedent's problem, because the decedent came looking for a fight, and the defendant didn't want any fight. Now, she said, now the prosecutors, they tried as hard as they could. They tried as hard as they could to instill hysteria in the jury. They threw all kinds of irrelevant arguments at the jury. For example, the second prosecutor said, and she was screeching and screaming at the top of her lungs like a banshee, this dishonest creature, the second prosecutor. She said, and one of the decedent's friends said, "Are you serious? You stabbed her." And the prosecutor was screaming out these words, "Are you serious? You stabbed her." That's what one of the other persons that had been in the car with the decedent, and who also, by the way, after she had used the knife, that other person jumped on the defendant and started attacking her. She was going to attack her anyway, before she saw the knife, but she started attacking her. Now, I'll get back to that in a minute. But the fact that the other person cried out, "Are you serious? You stabbed her." Why would the prosecutor relate that to the jury? I mean, why would the prosecutor tell the jury that? That has no relevance. Well, what was she trying to do? She was trying to whip up hysteria in the jury. She was trying to get an emotional reaction from the jury that had nothing to do with the relevant law and the relevant facts. The one witness, one of the antagonists, a friend of the one who was deceased, who ended up deceased, testified, and I don't believe her because the defendant testified that this was false. But just suppose this was true. Just suppose this is true. It still doesn't make the defendant guilty. This is what I'm talking about. She said that the defendant laughed and smirked and said, "I don't care," afterwards, after she had defended herself by killing the assailant, the chief assailant. Even if that's true, and I don't believe it's true, but suppose it, let's just say for the sake of argument that that's true, that she laughed and smirked and said she didn't care. What did the American people do on Times Square when World War II was over? What did the American people do? They laughed and they said they didn't care about anything or anybody. They were very happy that day because the war was over. And they were very self-satisfied and very content with themselves. And they were embracing and kissing each other on Times Square. It's in all the old newsreels. You'll see it if you haven't seen it already. Either on VE Day, so-called, or VJ Day, or both. Back in 1945. There are many old newsreels showing a gala celebration in Times Square. All the people laughing and dancing and hugging and kissing each other, making merry, rejoicing, because the war was over. Would you say that that made the American people guilty in that war? There are some people who have said that our fighting in that war was unjust. Well, I'm not talking about that here. Most people, most Americans, at least as of this moment, would say, if you ask them, that we were on the right side in that war, that we were fighting a defensive war, that we were the defenders, not the offenders. And yet we rejoiced when the war was over. Even if she did say, I don't care, and even if she laughed, even if she smirked, that doesn't make her guilty. It was still an act of self-defense. The other one had been harassing her for 8 months. She said on the witness stand, the defendant herself, that she had avoided any kind of fight for 8 months. And there's no disputing that. Nobody contradicted that. She said this was the first, she said this was not only the first fight in which she had used a knife, she said this was the first fight she had ever been in under any circumstances, the first actual physical confrontation. She said, I'm the kind of person who always tries to avoid a fight. And nobody contradicted her. And her demeanor shows that too. Now, the prosecutor again said, truth and accountability. That decedent was made accountable by that defendant at that event. It wasn't the defendant's wish, but it was forced upon her. She had to defend herself. And that decedent was made accountable for the wrong that she was trying to perpetrate. Now, an innocent person doesn't bear any, is not susceptible to being forced to any accountability, except that if there's any, in the first instance, anybody who thinks about trying to bring a charge has to look and see if there is any charge to bring. In this case, there wasn't any charge to bring, and it should not have even been brought. The charge should never have been brought in the first place. Whoever instituted the charge against her, the charge of murder, and even if it had been a charge of manslaughter, that person was criminally violating this girl's civil rights. That prosecutor had to know that this was clear-cut self-defense. The others had come from another part of town looking for her. There's no way you can call that murder, and there's no way you can call it manslaughter. It was self-defense. Now, they try to impeach one of the witnesses who told what happened at the scene by saying, it was a young fellow, that he was interested in marrying her, and therefore his testimony is worthless. It's not worthless, because he's the one that made the 911 call, and he said that there was a knife involved in the 911 call, and he indicated, he used the female pronoun, she or her. He didn't use her name, but that's okay. He didn't have any obligation to use her name. he knew that she was the innocent party. He also said in the 911 call that she had been jumped. That's the expression that he used. She had been jumped, and she pulled out what he apparently thought was a pocket knife. He called it a pocket knife in the 911 call, and she used it. But he didn't lie. He told the truth, essentially the truth. It wasn't actually a pocket knife, it was a kitchen knife. But so what? He told the truth when he said that the defendant, or the one that had killed the other person, had used a knife, and that before she used the knife, she had been jumped. And she was being jumped or harassed for 8 months prior to that. Now, they quote certain jury instructions as saying that if the defendant showed an indifference to human life, well, that's absurd. That's absurd. What does that mean? Indifference to human life in general, or indifference to the human life of that person who was assaulting her? And so when a jury instruction is that vague and that amorphous and that equivocal, it's worthless. And it's unconstitutional. And it should not be any criteria. It should not be among the criteria for determining guilt or innocence. Again, they, let's see. I'm going down this list here. Oh, he says, do you hear the hatred in her voice on those answering machine tapes, those voicemail tapes? Do you hear here's what he says. Do you hear the hatred in her voice? That's what he says. Then he says, do you hear the ill will? Do you hear the spite? Now, as I said earlier, he's confusing two different concepts, whether out of stupidity and ignorance or out of malice on his own part, the prosecutor's own part. One way or another, he lied to the jury, or he misrepresented the truth to the jury about what the law says. Hatred is one thing. Ill will or spite or malice, they all mean the same thing, those three. Ill will, spite, malice, they mean the same thing. But hatred is different. As I said before, I'll repeat it here very quickly. Hatred does not necessarily mean malice. Hatred might be rightful hatred. Wrongful hatred, you can call malice. Please consider also. Now, another jury instruction, and I may have to continue this into a second session, but I have about 3 minutes left in this session. Another jury instruction, very important, quoted by both of the prosecutors, that self-defense is such that the action is self-defense if it was necessary to prevent imminent death or great bodily harm. First of all, she had no way of knowing that when they went about to assault her, and when they came screeching around the corner and had tracked her down from another part of town, she had no way of knowing what they were intending to do, but she knew one thing, that it was going to be something bad. It might have been death, that they were going to try to work on her. It might have been bodily harm. It might have been great bodily harm. It was going to be one of those three. Do you think she had an obligation to gamble? No. She had the right to take action suited for the worst possible scenario, to prevent the worst possible scenario. She had a right to act under those circumstances as if she had a fairly good certainty or even a certainty that they were going to try to kill her. Even if it was probably more likely that they were just going to beat her up. That's point number one, that she couldn't be sure what they were going to do. But point number two is that if it was any bodily harm, even a scratch, even a busted lip, and even if some lawyers wouldn't call that great bodily harm, she still had the right to defend herself even with lethal force. Yes, to prevent a busted lip. Yes, to prevent a scratch. She had the right to use lethal force. She had the right to use lethal force even if only to prevent a scratch or a busted lip to herself. Any judge or lawyer who tells you different does not know the law, or he's lying to you. And so these jury instructions are false law. They contradict the fundamental principles of genuine law. And the verdict has to be thrown out.
Whoa, that's it. We're out of time again. This is the John Savers Variety Spotlight Show. My name is John Savers. I'm your host. We've featured this interesting show. I hope you enjoyed it. Hope to see you again next time.